Hi, everybody. Hope you all had a great Thanksgiving. We're back here today with Matt Grumbling, and today we are talking about trademark licensing, and he'll be talking to you about options for monetizing your brand. I am recording this session, so if you missed something or you want to go back and watch it, you can find it at the Surprise Economic Development YouTube channel. You can always contact Matthew or myself as well. Hi, Matthew.
Hi, how are you doing, Julie?
Good. How are you?
I'm doing well. Doing well.
Hope you had a great Thanksgiving.
I did. You?
Who doesn't love Thanksgiving? I love it. It's my favorite. So.
Yep, it's pretty good. Yep. So shall I get started here?
Sure.
Okay. So my name is Matt Grumbling. I'm a patent and trademark attorney, and I'm with the firm of Nguyen Tarbet LLC. This is our website up here. Here's my email address, matt@ntiplaw.com. And I'll be talking about trademark licensing today. If you happen to catch my patent licensing, you'll see a lot of common themes here, but there are some differences between trademark licensing and patent licensing, some things to think about along the way. So, and now, you know, in trademark licensing, I also cover a couple of other, another couple of issues. And let me click on this and get started here. So today's topics, I'm going to talk first about assignment, and then we'll talk about licensing and then enforcement. And enforcement, I think, is an important part. First off, licensing often comes up in settlement agreements regarding enforcement of your trademark rights. And also, and let me make sure this is out of my way so you can see everything. So enforcement, yeah, licensing comes up in enforcement, and there are some other issues as well that we'll cover. So let's talk first about assignment. Assignment means sale. So when you sell and I'll compare this to patents. When you sell a patent, you can just sell a patent, and you record that assignment in the USPTO, or the buyer will record it in the USPTO, and that's it. All sales are final, and you don't have to worry about it anymore. With trademark assignments, it's a tad bit more complicated. Because you have to sell the goodwill of the business, or at least that portion of the goodwill of the business that goes with the trademark. So if the trademark covers the entire business, you're basically selling all the goodwill of the business, and you can't do business under that name anymore, under that trademark anymore. So if you, let's say you're in you were a chiropractor and you had and you had some sort of mark that covered your chiropractic practice, once you sell the trademark, you don't get to kind of claw back some use of that. It's either completely sold or it's not. And that doesn't mean you can't be a chiropractor anymore. It means you have to pick a different name for your chiropractic business. And you know, I hope that's fairly clear. What they don't want to happen is they don't want somebody going out there and registering a whole bunch of trademarks and then just selling them, which has happened not so much in the trademark area, but it's happened in the sale of URLs, top or domain names for business sites. And people will go out there, they call it cyber squatting. They'll basically buy some nifty name that they think would make a great trademark, and then at some point in the future they'll sell it, and they'll make, it costs them a small amount of money to register these sites, and then they'll sell them for 10 grand, and it's really 10 or 20 grand or maybe more. And this is not supposed to be permitted, but it takes a fair amount of work to undo that. So one of the requirements for acquiring a trademark is that the goodwill of the business goes with it. Now, when you're doing an assignment, valuation is key, and this is true in licensing as well. How much is the trademark worth? Probably depends on how much goodwill there has been built up in the trademark. You think of a trademark like Miracle Whip, say. Everybody knows what Miracle Whip is, whether you like it or you don't like it, you know what it is, it has a brand recognition to it, and it's probably worth a lot. If I were to just make up a trademark name and start selling some sort of widget under that trademark and then sell it tomorrow, probably not as valuable. So you're going to look at things like, there might be a running royalty type of situation where there's a present assignment, but there's a promise for future royalty on that. There may be some percentage of an anticipated profit that comes from the sale of that trademark. And, I'm using these numbers as, a comparator of some sort. 1 to 10%, and so maybe in 2 to 3%, depending on really how much effort was put in on the front end of this to develop the trademark. And that's how much that, you can expect some percentage to be based on the perceived value of the trademark. If you set the bar too high, the buyer may just run and develop their own trademark. So you have to think about it in those terms. You've invested a fair amount, say, into your trademark associated with a certain type of goods, and now that saves somebody else the trouble of developing their own mark. That differential there, that trouble that they would have had to put into developing that mark and developing that market, that's where the value is. So you might look at anticipated profit or some percentage of sales, maybe 0.5 to 5% of sales. And again, it's, these things are going to depend a lot on whether we're talking a commodity or something that maybe has an associated patent or know-how, trade secret know-how that, when you think about Coke, if you happen to own the Coca-Cola brand and all of its associated trademarks, Coca-Cola, that particular script in association with Coca-Cola, all the red and with the white lettering, all those things. You owned all that, and you had the trade secret of the formula. That would be pretty valuable. If you are selling it, as a naked sale of just of one of those trademarks, maybe not so valuable. So that's the assignment issue. Assignment almost always happens when you're selling the business itself. So, if not the business, at least that part of the business that covers the goods or the services that are covered by that particular assignment. Now, the more common situation is licensing. And a license basically means you get some bundle of the rights that go along with the trademark, but you don't get all of them. And how many of those rights and to what degree you get them, that will affect the amount of money that you can make from the license. So here are some general licensing considerations. Is this going to be an exclusive use or a non-exclusive use of the trademark? And there are situations where perhaps you will use it here in the United States, but somebody else will use it in another part of the world. Or maybe you will use it in the state of Arizona, and you will license the use of that trademark to a franchisee over in California. Those are two possibilities there. And of course, I brought up franchise. There's a whole body of law on franchise law or franchising. So you can see that there's some interlacing of these different types of legal considerations. is this going to be part of a larger agreement that maybe a manufacturing or an importation agreement or a distribution agreement or something like that? These are going to be considerations to take into account. Will the licensee be able to fulfill all the demand for the product? Well, that's going to feed back into whether this is going to be an exclusive or non-exclusive. Maybe you grant a non-exclusive license, or maybe you give a territory of some sort. I said, do you want to limit a licensee's region? And I already mentioned this, but maybe you want to give them the Eastern United States, and you will handle the Western United States. And there are all sorts of different ways you can break that down. And you have, once it's federally registered, you have all the freedom you need to limit things by region or whatever. You want it to be forever, or do you want it to be, you want it to be for a period of time? Maybe you give a 10-year license to this. Maybe you make an exclusive for the next 5 years, and then with an option to renegotiate or an option to extend or something like that. So these are all strategic questions that will need to be somehow embodied in whatever writing you reduce this licensing agreement to. And then the last one, probably one of the more important ones, is who will be able to enforce the rights. And oftentimes a licensee will want to have the option, if you, let's say you as a trademark owner, you license to this licensee, and let's say you or they discover an infringer. One of the ways this could be set up is that you might have the first right as a licensor to sue to enforce that trademark. But if you demur, if you say, well, I don't really want to take on this infringer, or for whatever reason, maybe I don't think it's a very good case. Maybe I don't really think that their use is infringing or whatever, that the licensee might have the option to then jump into your shoes and take over the enforcement as long as they pay the price for it. So those are some things that, licensees, now they may not, maybe in say a franchising situation, you might not want to give that to your franchisees, because that should be something that's centralized in the corporation. But they might still have a reporting requirement, that if they discover a potential infringement, that they have a requirement to report that, and if they don't do that, then there would be some repercussions, up to and including that's a breach of contract, and maybe the license becomes null and void. These are all, these are kind of on the table as you're thinking about, or they should be on the table as you're thinking about licensing your trademark. By the way, if you're the potential licensee, these are also things you need to consider. You want to be able to jump into the shoes of the licensor if you discover an infringer and you want to sue them. And some other things to think about: can the trademark be applied to more than one product? Maybe right now maybe you're in the battery business and it covers a battery, but maybe you'd like to get into the battery accessories, or you'd like to get into more automotive accessories and things like that. This actually overlaps a lot with the considerations that you would have in a patent case. And if you want to look at some more ideas for that, you can go back and look at my patent licensing slide deck. But you can imagine, one trademark might be very, very valuable for a number of different things. So here's some common licensing terms: royalty or non-royalty bearing. The royalty bearing, I would say, are more likely for an exclusive license or a non-exclusive license. Non-royalty bearing or paid up might be more of probably a settlement condition where there may be some allegations of mutual anti-competitive conduct or mutual infringement, or maybe in the sale of the company or sale of the brand outright. You might have a non-bearing paid, just fully paid up license there. There could be milestones. There could be things like, well, if you sell 5,000, that's going to be this much. If you sell another 10,000, it will be that much. Milestones often stand in the place of royalty, or they're kind of an addition on top of royalty. You can think of situations where there might be some royalty stacking, not so much in the trademark licensing space, but that can happen. Again, exclusive or non-exclusive. I threw in covenant not to sue here because a covenant not to sue is basically a non-exclusive license. It's basically saying you can go ahead and keep doing what you're going to do. And these actually come up, again, where you have sort of very closely related trademarks. Maybe one is a common law trademark. The other is a federal trademark that's become non-contestable. And, the common law trademark still has some weight to it for a limited market, but the federal trademark has that incontestability built into it, and now it's kind of hard to break the federal one, but there's priority in the common law trademark. They might enter into a covenant not to sue. You stay on your side of the fence. I stay on, kind of divvy up the sales market. Maybe you sell in a more exclusive type of shop where you can charge $100 per unit. I'll sell on Amazon where I only make $10 a unit, and we'll divvy up the market that way. And when we do that, we may just enter into a covenant not to sue each other on our respective trademarks. Here's the field of use. If you want to, maybe the trademark covers a number of different products within a certain industry, then maybe you only want to license somebody to manufacture and market a particular one of those products. So, you might limit it to that, or you may put in some other limitations, again, based on the market that's being served. Again, I think I mentioned territory. I said region earlier. I said earlier, same thing. All of the United States, or one or several states within the United States, East Coast, West Coast, whatever, however you want to divide that up. Here's some other licensing terms. What are the efforts you're going to? You're going to see all of these: reasonable, best, blah blah blah. These are kind of buzzwords that are used. They're terms of art that are used, and but they're supposed to indicate a particular type of diligence that the licensee is going to use to market. So in and that usually comes up in a royalty bearing or a milestone type of situation where, if you're the licensor or you're the assignor, what you don't want to have happen, especially if you've got an ongoing royalty or you're expecting milestones, is you don't want the buyer of that or the licensee of that trademark to just park it. Buy it up so that they won't be able to compete, or you won't be able to compete with their product. And that can happen. So, you're going to, one of the things you can put in there is just a requirement that they use the reasonable efforts, reasonable best efforts, something like that, to market the product under that particular trademark. Let's see. Again, enforcement rights are important. Who gets to enforce? Termination. On what basis are we going to terminate this contract? Some terminate based on a planned set of circumstances, 5 years, 10 years, something like that. Others, and usually these won't be exclusive. You'll have maybe a term, 10 years or something like that, or a breach. And, and then you'll have some conditions that result in the license agreement terminating on its own conditions. Let's say failure to pay royalties would be a typical type of breach. It's it's fairly familiar to us, but there could be some other breaches in there. Now, what happens after termination? And that's an important term there, because there are going to be things that there's going to be confidential information, for instance, that will have been shared between the parties, and there will probably need to be some provision for maintaining confidential information for at least a period of time, if not indefinitely, after termination of the license agreement. Let's see, maybe rights to additional trademarks. If there are, some common, overlapping or related trademarks, you might bundle them up. Like for instance, if there were different symbols and things like that, or word symbol combinations, things like that. And I've already mentioned confidential information. Yeah, so what rights are included? Sometimes there's an indemnification clause. An indemnification might hold the licensee harmless from the licensor harmless from things the licensee does with the product. Maybe this is part of a manufacturing license, and the licensee is going to manufacture and market this good. If it's the kind of thing that can be manufactured improperly and cause harm to people, which just about everything can, the licensor, having sort of given this to the licensee to do under its own name, might want to be indemnified from any sort of say liability lawsuits, strict liability or negligence lawsuits that might come out of that. There might be limitations on the liability. It's similar to indemnification. Maybe as the licensor, you don't want to be on the hook for anything more than what you've received to license this to the licensee. So there might be a limitation on your liability there, and it could be a mutual limitation on liability. So I just talk a little bit about enforcement, because a lot of times licensing pops up in an enforcement context, and by enforcement I mean usually a lawsuit that includes an allegation of trademark infringement. It could include other things as well. And normally trademark suits have some elements of state court, state court type of causes of action in there. Things like fraud or, unfair competition, various state unfair competition laws and things like that. So the first step in enforcement is usually a letter sent by the trademark holder to an infringer. It says, please cease and desist. These letters, they give notice to the infringer. If they continue to do it, if they continue to infringe after they receive notice, they could be on the hook for enhanced damages. These letters can also be licensing offers. Hey, we notice you've been using our trademark. We put a lot of work into our trademark. We're very proud of it, but we respect you as a manufacturer and distributor of these kinds of things. and hey, how would you like to license it? We don't have to be enemies. We could be friends, and you just have to pay us for that. And then finally, there's the cease and desist letter, which basically says stop doing what you're doing, and don't do it anymore. The cease is stop doing it. Desist is don't do it anymore. And usually there's some sort of a demand in there for some sort of an accounting. It's kind of pro forma unless unless it's been going on a while and they've made a lot of money off and stolen a lot of business from you. Then that can be a lot more serious. Now, the warning I have here on cease and desist letters is that they can grant the recipient of that cease and desist letter a right to go to court and settle the dispute in court. Now, it's called a declaratory judgment action, or a DJ action. The thing about a DJ action is basically you give the infringer the power to file a lawsuit as a plaintiff, and that gives them their choice of venue to a certain degree. That said, that's not as much of an issue as it used to be, because it used to be that you could sue anywhere, basically, that the trademark was being used, and you as the license, or as the trademark holder, would want to have that power. It's now a lot harder to do that, to file just anywhere. So the declaratory judgment action is not as big a deal, but it does give the infringer the potential to maybe find, if there are a couple of courts that they could file and maybe find the one that's more suitable for them. So you still have to be concerned about that. And so as a result, a lot of times before we send a cease and desist letter, we'll actually prepare a complaint and file it without service. So we're the first filer, and then we can go ahead and if necessary, if the ceasing and desisting doesn't take place, then we can go ahead and perfect it by serving process on the infringer. I've already alluded to lawsuit. Generally speaking, they're filed in U.S. district courts. That is permitted under the law. It's not required. You can file a trademark suit in state court. It's just usually they will be removed to district court anyhow, because the two parties are rarely ever residents of the same state. And if it's filed in say the state court of Arizona, and it could probably be removed to the district court of Arizona, and under the federal statutes governing the venue and whatnot. So it's generally where the infringer resides, and for a corporation or company, that's where they are incorporated or where they have their principal place of business. Let's see. And most often enforcement actions end in some sort of a settlement. And sometimes there is it actually goes to trial, or it's actually tried to a jury or to the court itself, which a judge will make the decision. That's called a bench trial. But often there's a settlement, and there's usually some sort of an agreement reached, a license agreement of some sort, and that's when we get back to the licensing thing. So the last thing I'm going to talk about is trademark appeals, and I'm just going to mention one little thing about trademark appeals, and that is, if you're not happy with your district court judgments, you can you can take them to one of the circuit courts of appeal. And if, let's say, you sued in Arizona, you would take them to the Ninth Circuit Court of Appeal. And that's all I'll really say about that. There's a really, really low percentage chance you could get beyond the circuit court. But the Supreme Court has taken up a few cases in the last few years, but they have to be hotly contested points of trademark law in order for them to make it up to the Supreme Court. So that's about all I have to say about that. Thank you for your attention. I put my contact information again in case you contact me or ask any questions, and that's it.
Thank you, Matt. Again, that's always great content that you have. Again, as I mentioned before, if you need to go back and watch these, you can go to the Surprise Economic Development YouTube channel. All these videos, these webinars are on there and they're recorded. You also have Matt's information. Thank you for joining us, and tune in next week to learn some more about some other trademarks. I believe next week is trademark battles, oppositions, and cancellation proceedings. So always good to know about that. Thank you, Matt. I can't hear you.
Thanks, Julie.
Oh, thank you. Have a great week, and we'll see you next Tuesday.
All right. See you.
Okay.